What's up, guys? Let's talk trial. This is my second video on the Derek Chauvin trial with the cop who's been accused of murdering George Floyd. And I finished watching the opening statement for the prosecution, and I did a video on that yesterday. And now I finished watching the opening statement for the defense, and this video is about that. And just kind of along the same lines as the last video, where we talked about certain things that we could learn from the opening statement, certain things that we could do better if we're trying a case, if we're trying to get better at the art of trying cases. And so this video is also along the same lines. Like I said in the last video, this isn't about second guessing all the trial lawyers' work. This isn't about saying whether they did a good job or a bad job or anything like that. That's not what this video is about. This video is about how can we get better at trying cases by learning from what other people are doing and what works and what doesn't work. So I'll get right down to it. Just like the prosecution, the defense opening statement did not make use of the primacy of the case. Basically, the defense attorney got up there. I spent the first 5 minutes talking about reasonable doubt, and then spent like the next 5 minutes talking about how good a investigation the state did and how thorough an investigation it was and how many thousands of pages of documents there were and how many interviews were taken and all that kind of stuff, which I'm not really sure why that's going to be important. I'm not even sure if it's going to be important, but it's an interesting way to waste the primacy, the first 5 minutes or 10 minutes of what the jury's going to hear. And there's a reason for that. And I'm going to talk about specifically about the reasonable doubt conversation that was being had in opening statement. And before I do that, I want to tell you, this that I'm about to say is far from a consensus in the trial community. What I'm about to say is probably considered blasphemous by a lot of the criminal defense community. There was a previous time in my life when I tried a lot of criminal cases, and that was all I did was try criminal cases. I don't really do that anymore, but I do have a significant amount of experience trying these cases, and I have a lot of friends who try these cases. And I can tell you that I have never, ever believed in reasonable doubt as a defense to a criminal case. Reasonable doubt is a burden. Reasonable doubt is a measuring stick. Reasonable doubt is not why you did not do what they're saying you did. And the counter argument to that people make is, well, by people I mean lawyers. I can guarantee you actual people, non-lawyers, don't really think this way. But the alternative argument that people make is they say, well, Igor, like, you don't understand. I'm going to get up there and talk about reasonable doubt, and they're going to go deliberate, and they're going to understand that it's such a high burden, and I'm going to just say all the things that create doubts, and that's going to be my defense. And that sounds interesting to me because, let me put it this way. Let's take it out of the courtroom. Let's go into normal everyday life, because the jurors are normal everyday people. Let's say you have kids, and let's say you find out that your neighbor next door got arrested for allegedly raping 7 children. Let's say he gets out of jail, and you see him outside his house, he's doing his yard work, or he's cleaning his car or whatever, and you walk up to the guy, and you say, hey man, I learned that you got arrested for allegedly raping 7 kids. What's up with that? Did you do it? And the guy tells you, well, it's going to be a lot of reasonable doubt. It's a lot of reasonable doubt as to whether I did it or not. So there'll be a lot of reasonable doubt as to what happened that day or those days or whatever. It was just a lot of reasonable doubt, man. How would you feel about that? Are you going to let that guy babysit your kids? Probably not, and with good reason, because if the best that he can tell you is that there's going to be a lot of reasonable doubt, that sounds to me like he did it, and he's just thinking maybe I won't get convicted because there's going to be all these reasonable doubts that won't match up to, or the state won't be able to overcome, and so I should walk, right? It's as close as it can get to saying that you're going to win on the technicality. And to me, I think the jury feels exactly like that when they step into a courtroom as when they are outside the courtroom. I don't care how many times the reasonable doubt instruction gets read to the jury. Most reasonable doubt instructions suck anyway. Like when you read that to a jury, they don't understand what the fuck that means. It's just, even lawyers, even us who've been trying a lot of cases and have that instruction read in the beginning of the trial and at the end of the trial, we go to a charging conference and it's always in there and this and that. Even us half the time don't understand what it means and disagree as to what the explanation is supposed to be. So I definitely don't think that jurors go in there thinking, oh man, reasonable doubt, great. I think I feel so good about walking this guy because there's some reasonable doubt in here. That's realistically not what happens. Realistically, what happens is there's a narrative that is told based on the evidence that suggests to the jury that the guy did not commit the offense, meaning this guy is actually innocent. And then the jury goes in the back and they have obviously the state's evidence, which may or may not be substantial. And then they have the defense evidence, which may or may not be substantial. And they put it back and forth and they try to fit into their theories and try to figure out, am I going to send an innocent guy to prison or not? And if they cannot make a decision because they think, man, I don't know if this guy did it or not. I think he may be innocent. He may be guilty. I don't know. I'm struggling with that. Then maybe as a fallback, they go to the jury instructions and say, well, if we're struggling with that, then he should be found not guilty because this is what the standard says. But there's nobody that's going in there thinking, oh yeah, I definitely want to walk this murderer because there's reasonable doubt. I love to walk murderers when the state can't prove the case beyond a reasonable doubt, even though I think he did it, and even though the defense not even saying he didn't do it, right? So, not great. Probably the most effective way to try a case like this to a jury is to start the primacy of the opening statement with your version of events in a story-like fashion told through the eyes of your client, but as he is watching the actions of the victim in this case. Basically, you have to put the jury in your client's shoes and walk them through the story in the light most favorable to the client. Obviously, if you tried a few cases, it's golden rule and this and that. That's not what I'm saying. It's about telling the story in a fashion that accomplishes that result without violating the golden rule, which I don't even know that Minnesota has the golden rule, but that's, I guess, kind of besides the point. So anyway, the primacy was kind of a big issue. The big words was also an issue. The prosecution had the same issue on the primacy, and the prosecution had the same issue on the big words. I think the defense guy was a little worse. At some points, he was saying stuff like further evidence of concealment of controlled substances. I mean, I know what that means, but damn, that's a hell of a way of saying you're going to see that there was a lot of evidence that he was hiding the drugs, or you're going to see there was a lot of things indicating that he's hiding drugs. So you're going to see that he's trying to keep the drugs away from the cops finding them, or however you want to say it. That's a hell of a way of saying that, and completely unnecessary. There's no reason to use those words other than you get used to speaking like that, and you think that normal people speak like that, and then you kind of get caught up in that process when you don't really think about it too much. So that obviously not great, and we can definitely learn from that and improve on that when it's time to try the next case. The next thing that I thought could have been done in a different way, in a perhaps more effective way, is the medical evidence in this case appears to be pretty devastating for the prosecution. The defense attorney brought that out like 30 minutes into his opening. I don't know, somewhere towards the end, it was the first time that he mentioned it. It should have definitely been mentioned in the beginning. I think if you want to do a more effective version of this opening, you start with the story as to what happened that day from the light of the defendant and what the situation was. And then you shift into what will likely be the most persuasive evidence in the case, which is the medical evidence. And in this case, it appears that the most persuasive evidence in the case, as far as the medical evidence is going to be, that the medical examiner, the guy who works, or the lady who works for the state attorney's office, the people who are prosecuting the case against the defendant, that person found that George Floyd did not die from asphyxiation, that there were the signs that you typically see when somebody dies from a lack of oxygen were not present. The kind of physical objective findings that would tell a trained medical professional that this person died from asphyxiation are not there. and that there were contributing causes that were found by the medical examiner, like heart disease. He had other medical issues that are contributory to, or not that are, because this is what the evidence is. This is not like this is what happened or what didn't happen. The medical examiner is going to say that's what it was. And so if you're the defense, there really cannot be any better evidence than the state's own doctor saying that what you're saying is true, right? And if that's the case, I see no reason why you wait till the end of the opening statement to bring that up. If you're going to bring that up, you bring it up early on. You set the tone right away. Basically, look, this is what these guys are saying, and that's great, but let's talk about what really went down from a medical perspective, right? So that was, I don't know, it doesn't make a lot of sense to me why it was done the way it was done. Maybe there's a reason for it, but as of right now, it's kind of unclear what's happening there. And finally, another issue that the prosecution also suffered from, but the defense seems to suffer from as well, the defense is not addressing the bad facts in the case. There are very bad facts in this case for the defense. Number one, you have your knee on a guy's neck for 9 minutes and like 24 seconds, or however long that was. And for a lot of that time, the guy isn't moving. So that's pretty bad, because at the end of the day, if you have something like that going down and your defense has got to be that, oh, you use reasonable force to restrain the person and blah, 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 you got to figure out how to explain to the jury why it was necessary to keep your knee on the guy for 9 minutes and 24 seconds when he was already not moving, right? And that was something the defense didn't even touch. And it's going to be a problem because that's something the jury's definitely going to be discussing. There is no human being on this planet who's going to go through this trial, go deliberate, and say, you know what? We don't have to talk about the fact that the guy wasn't moving and they kept the knee on him for 9 minutes and 24 seconds. That's just not reality. That's just not what happens. So that is going to happen. And so the question is, why would the defense not touch on it? If what the defense is thinking is that, oh man, it's so bad that I don't want to draw attention to it, that's a problem, because that is a key to the case. And if your strategy to address a key to the case is I'm not going to deal with it, I'm going to hope for the best, that's not really going to be working out too good for you. You know, the jury's going to want an answer. And the only side providing an answer right now is the prosecution. And what they're saying is that Chauvin's a murderer and put his knee on him unnecessarily for 9 minutes and 24 seconds when the guy wasn't moving. And you know what? That's a good point, right? So you got to do something about it. Now the medicine helps, right? But if you're going to address it, if your angle to it is, look, maybe he should have taken his knee off of him at some point, right? But that did not cause his death. Then you got to come out and own it. You got to be like, look, you know, it was a crowd. It was a big crowd. People were saying certain things. It was hectic. We were waiting for backup or whatever. And you know, maybe he should have taken his knee off 4 minutes before or 5 minutes before. But during that time, everything's moving so fast, you're not really keeping track of time like that. I don't know. Whatever the explanation was going to be, there had to be one. This just can't be made up like that. So, or not made up, left unsaid rather, like that. And so that's going to be a big problem, I think. And it's kind of weird to see both of these lawyers who appear to have tried a lot of cases both make the same mistake, in my view, which is not addressing the bad facts with the jury. It's going to hurt both of them. Now, what's interesting about it, though, is that because both of them are doing the same thing, maybe the jury is not really going to like realize it, or maybe the jury is not really going to hold it against either one of them, which I guess is kind of the best that they can expect. But if this was a situation where one side was holding back the bad facts and the other side was coming clean with the bad facts and explaining to the jury why they don't really matter all that much, then the jury would hold it against the side that's not talking about the bad facts. Because they will see, look, that's not how this is supposed to go. That guy's telling us how these things are going to come out, and that doesn't sound too great, but he's telling us about it. That other guy didn't tell us about any of these things. And so it's not because this is how it's done. It's because that guy's lying to us and hiding stuff from us, and that other guy isn't. Who are we going to believe when it comes down to making the call, right? And the last thing on the defense opening, which actually the prosecution did way better at this than the defense, the defense was reading way too much of the opening. And I don't mean like you have notes in front of you, you look down and then you look up and you say what you're going to say. That's not what was going on. He was literally putting his eyes down and reading from a piece of paper and then looking up and then doing it all over again. And basically, at key portions of the case, he's not speaking to the jury. And it's clear that he's not speaking from a sound base of knowledge, but rather he's reading whatever's written down. Now, you may say, well, what's the big deal? What the lawyers say is not evidence. The judge instructs the jury that the lawyers, they're not witnesses in the case. Like, who cares if they're reading, if they're not reading, whatever. Here's how I like to look at it, right? When I go into a trial, I know all the facts of the case. I know everything. I know stuff that's going to come into evidence. I know stuff that's not going to come into evidence. I know what happened, how it happened, when it happened. I know what the story is going to be from both sides. I basically have a full mastery of the facts. When I open, and opening is my favorite thing to do. When I open, I never have any notes with me, no matter if it's 15 minutes or an hour. It doesn't matter. You got to get up there and have the full knowledge of the presentation that you can go without notes. And the reason I do that, which I think is very important, is because regardless of what the judge tells the jury, regardless of how many instructions you read them, there is a subconscious element to this where the jury is going to be thinking, okay, I'm hearing different versions of the story. Who do I believe more? Who's the most credible? Who knows what they're talking about, right? And if you're reading critical portions of the opening, if you're reading, in my mind, any part of the opening at all, and not making eye contact with the jury and not speaking from the heart, the jury's going to think this guy doesn't really know what he's talking about. He's reading it, he at some point heard it somewhere and put it down on paper, and he's reading it to us. That's not what I want in the cases I try. Cases I try, I want the jury to look at me and say, that guy knows what he's talking about. That guy knows everything about this case. And so it's not that I think they're going to take what I say and believe that it's evidence, but it's a subconscious element of this where they think, rightfully so, that I know what I'm talking about and that I could be trusted to deliver the true facts of the case. And I think that's probably as important as any quality of witnesses that you may put on. And so if you're reading from a piece of paper to the jury about the facts of the case, that's a problem. And it's something that I think it's easily fixable. It's something that can be worked on. And it's something that maybe lawyers do it and they don't think it's a big deal, right? Like maybe you see 15 trials and out of 15, maybe 13 of them are reading from a sheet of paper like that. But I like to be not in the majority when it comes to this kind of stuff. It's the kind of stuff that takes a little bit more effort. It takes a little bit more effort to know exactly everything that needs to be said without needing to look at a piece of paper. But at the end of the day, it increases your credibility with the jury, which ultimately should help obtain the result that you want to obtain for your client. So anyway, guys, that's it for now. I'm going to do more of these videos as the testimony develops, or rather as I catch up to the testimony that has already developed. And I'll give you my takes on some of the testimony, some of the directs, the crosses, and what I thought about them, and how we can improve and get better from them. So that's it for now, guys. I'll catch you again next time.